If you have been watching the Visa Bulletin every month, February 2026 just delivered a surprise that can change real timelines overnight. EB1 dates moved backward. And if you are from India or China, this is the kind of shift that can turn a plan to file right now into a longer wait, or turn a case that felt close into something that needs patience and tighter planning. By the end of this video, you will know 3 things clearly. 1. What EB1 retrogression actually means in plain English and why it happens. 2. How to tell if you are affected depending on your country, category, and whether you are filing inside the US or through a consulate. And 3. The practical steps you can take right now to protect your green card timeline and avoid common mistakes while things are moving. Now, before we go any further, a quick, calm but important reminder. The Visa Bulletin is a monthly snapshot of visa number availability. When dates go back, it does not mean your case is denied. It means the government is managing limited annual numbers and demand. Your job is to respond strategically, not emotionally. Here is the part most people miss. The word current means different things depending on which chart applies to you, where you are applying from, and whether a visa number can actually be allocated at the final step. So let's break this down cleanly. First, what changed? In February 2026, the big headline is EB1 retrogression. Retrogression simply means the published cutoff date for a category moved earlier than it was before. In normal months, you hope dates move forward, letting more people become eligible. Retrogression is the opposite. The cutoff moves back, meaning fewer people are eligible at that moment for the step that chart controls. In a quota system, this happens when demand is higher than the available visa numbers, or when agencies are trying to pace approvals and avoid using more numbers than they have. Think of it like a concert with limited seats. If the organizer realizes too many tickets were released for a section, they stop letting new people in, and they may tighten the entry rule. That is retrogression in Visa Bulletin terms. Now, when people hear EB1, they think best category, fastest lane, always current. That is a myth. Myth versus reality. Myth: EB1 never backlogs. Reality: EB1 can and does backlog, especially when demand surges from certain countries, when more people upgrade from EB2 to EB1, or when overall employment-based demand patterns shift. A small detail changes everything here. EB1 is not one single pool for everyone. It is split by country of chargeability. So even if the worldwide number looks healthy, a high-demand country can retrogress. And in your brief, the big concern group is India and China, where demand often concentrates. Next question: who is affected versus who is not? Let's do this in simple buckets. Bucket 1. You are likely most affected if you are EB1 and your country of chargeability is India or China and your priority date is close to the cutoff. If the dates moved backward, someone who was previously eligible to file or to be approved may no longer be eligible for that specific action until the date moves forward again. Bucket 2. You may be less affected, or not affected at all, if you are EB1 worldwide, not India or China, and the category remains current or less backlogged, depending on what the bulletin shows for your chargeability. Bucket 3. You might be indirectly affected even if you are not EB1, because EB1 movement can influence behavior. For example, when EB1 retrogresses, some people stop trying to upgrade, some people switch strategies, and demand pressure can shift to EB2 or EB3 over time. That does not automatically change those categories in the same month, but it can affect the trend. Here is another point that causes a lot of confusion. Your country of chargeability is usually your country of birth, not your passport. If you were born in one country but hold citizenship of another, your chargeability typically follows birth country rules, with some exceptions like cross-chargeability through a spouse. Do not assume your passport changes your place in line. If that is your situation, that is a good moment to verify your chargeability on your paperwork and talk to a qualified professional if you are unsure. Now let's talk about the two charts, because your brief mentions something important. USCIS continuing to use the dates for filing chart. This is one of the biggest reasons people inside the US sometimes still have a pathway to file even when final action dates look worse. The Visa Bulletin usually includes two charts for employment-based categories: dates for filing and final action dates. Dates for filing is about when you are allowed to submit your I-485 adjustment of status application, if USCIS chooses that chart for that month. Final action dates is about when a visa number can actually be issued or when USCIS can finalize approval, depending on the process. Here is the key. Being able to file is not the same as being able to get approved immediately. Filing can still be hugely beneficial because it can unlock benefits like the EAD work permit and advance parole travel document, and it can put you in the pipeline. But approval still depends on a visa number being available under final action dates at the time of adjudication. Myth versus reality. Myth: if my priority date is current on dates for filing and I file I-485, I will get the green card quickly. Reality: filing gets you into the process, but final approval typically waits until final action dates are current for you and a visa number is available. Now let's separate two groups because they experience retrogression differently. People filing inside the United States with I-485 and people doing consular processing outside the US. If you are inside the US and eligible to file under the chart USCIS selected, you might still be able to file even in a month that feels bad. That can be a big deal. If you are outside the US and relying on a consular interview and visa issuance, final action dates often feel more directly controlling because the consulate needs a visa number at issuance time. Either way, when EB1 retrogresses, there can be delays. Interviews might be scheduled later, cases can pause at the final step, and agencies can slow down final approvals to manage the annual cap. Here is where people get tripped up. If you already filed an I-485 when you were eligible, and then later retrogression happens, that does not automatically cancel your filing. Many cases remain pending until the date becomes current again for final action. But you need to plan for the wait and keep your case healthy. Respond to requests for evidence on time. Keep your address updated. Keep underlying status plans in mind, and avoid travel mistakes. That leads to real-world consequences. Let's make this practical. Consequence 1. Timing of filing. If you were preparing to file based on EB1 being current, retrogression can suddenly mean you cannot file this month unless your priority date is still within the applicable chart cutoff. So you may need to pause, or you may need to file in a different category if eligible, or you may need to wait for a future bulletin. Consequence 2. Processing expectations. If you already filed and you were hoping for a quick approval, retrogression can slow the final step. You may still receive biometrics, you may still get an RFE, you may still get an interview notice, but final approval can depend on visa availability. Consequence 3. Travel and work planning. If you file I-485, you need to understand how travel works. Leaving the US without the right travel permission can create serious problems in some situations. If you have H-1B or L-1, there are nuances people rely on, but you should not assume. Always check your specific situation with reliable sources. And with work, an EAD is helpful, but it also changes how you manage status and job changes, so plan carefully. Here is an example scenario to make it concrete. Example scenario. Priya is in the US on H-1B. Her employer filed EB2 years ago. Recently, she became eligible for EB1, and her company filed an EB1 petition. She has been watching the bulletin and expected to file I-485 soon. February 2026 comes out, and EB1 for her chargeability retrogresses. If USCIS is using dates for filing and her priority date still qualifies, she may still be able to file and get into the I-485 pipeline. But if her priority date no longer qualifies under the chart USCIS selected, she may have to wait. Either way, she should not quit her job impulsively, should not make travel plans assuming a green card is imminent, and should get her documents ready so that if dates move forward again, she can file quickly. Here is the bridge hook. Two groups are at highest risk of getting blindsided. Group 1 is people who were days away from filing and did not have documents ready. Group 2 is people who already filed but start making life decisions assuming approval is guaranteed in a specific month. Retrogression punishes assumptions. Now let's talk about why this is happening, in a non-political, process-focused way. EB categories have annual numerical limits, and per-country limits shape how quickly one country can move compared to another. Demand is not steady, it surges. In recent years, EB1 demand has been influenced by more people filing EB1 petitions, more upgrades from EB2 to EB1, and employers trying to use faster categories when possible. When more approvable cases exist than available numbers, the government uses the bulletin to manage the flow. Another factor is timing inside the fiscal year. As the year progresses, agencies adjust cutoffs to avoid exceeding annual limits. Sometimes they move dates forward to use numbers efficiently. Sometimes they retrogress when they see the pipeline is too full. And because USCIS and the State Department coordinate but operate different parts of the system, you can see months where filing is encouraged, dates for filing used, while final approvals are still constrained, final action dates more restrictive. Now, what about EB2, EB3, and family categories? Your brief says you will cover them, but we do not have specific cutoff dates provided here, so I am not going to invent numbers. Instead, I will tell you exactly how to read what changed. Step 1. Find your category. EB2, EB3, and any subcategory like skilled workers, professionals, other workers, or specific programs if listed. Step 2. Find your chargeability area, like India, China, or all chargeability areas. Step 3. Compare February 2026 to January 2026 for both charts. If a date moved forward, that is progress. If it stayed the same, it is stable. If it moved backward, that is retrogression. Step 4. Check whether USCIS says to use dates for filing or final action dates for I-485 that month. That decision determines whether you can submit your I-485 if you are in the US. For family-based categories, the same logic applies. You typically have a dates for filing chart and a final action dates chart. Family categories can move differently than employment categories because demand patterns and annual limits differ. Some family categories may see forward movement quietly, even when EB1 has bad news. Here is another hook. The quiet winners are often people who are prepared to file the moment their date becomes eligible. Movement is helpful only if you can act on it. Now let's go to the most useful part. What you should do right now. I am going to give you a practical do this and avoid this checklist. This is general information, not legal advice, and the right move depends on your facts, but these steps are safe and realistic for most people. Do this. Check the actual February 2026 Visa Bulletin directly from the State Department site, and do not rely only on screenshots. Do this. Check the USCIS page that tells you which chart to use for employment-based and family-based I-485 filings for that month. That one page changes everything. Do this. Confirm your priority date from your I-140 approval notice or your underlying labor certification date, depending on your case type. Do not guess. Do this. Confirm your country of chargeability and whether cross-chargeability through a spouse might apply in your situation. Do this. If you might be eligible to file soon, start preparing your document packet now. Birth certificates, marriage certificates, prior immigration documents, passport copies, and anything commonly required so you are not scrambling during a short window. Do this. If you plan to file I-485, also plan for medical exam timing, photos, and translations, because these practical items cause delays when dates suddenly open. Do this. Keep your address updated with USCIS if you have any pending applications, because missed mail is a very common reason people lose time. Do this. If you already filed I-485, keep tracking your case status. But also watch the bulletin monthly so you understand whether your case is waiting on visa availability. Avoid this. Do not make irreversible life decisions based only on one bulletin, like selling property, quitting a job without a plan, or booking international travel assuming approval will arrive before a certain date. Avoid this. Do not file something you are not eligible to file just because you saw a viral post saying USCIS is accepting everyone. Eligibility is chart-based and category-based. Avoid this. Do not ignore underlying status planning if you are in the US. Many people assume I-485 pending solves everything. It helps, but status and travel rules can be nuanced. Avoid this. Do not assume your friend from another country has the same timeline as you. Country caps can make two identical cases move very differently. Here is a second example scenario that hits a different group. Example scenario. Wei is abroad and his employer is sponsoring EB1. He is waiting for the National Visa Center and an interview. When EB1 China retrogresses, his case may still be documentarily complete, but the interview or issuance can be delayed until the final action date becomes current again. The action step for him is to keep documents updated, watch for NVC communication, and manage expectations with his employer and family about timing. Panic does not speed it up, but preparation prevents missed windows when dates move forward again. Now, let's do another myth versus reality because this is where people get confused. Myth: if USCIS uses dates for filing, everyone can file. Reality: you can only file if your priority date is earlier than the dates for filing cutoff for your category and chargeability. Myth: if my I-140 is approved, my green card is guaranteed soon. Reality: I-140 approval is a major milestone, but immigrant visa availability still controls the last step. Myth: retrogression means the government changed the law. Reality: retrogression is usually an administrative response to demand and annual limits, not a new law. Now let's talk about what could happen next, because watching the next 1 to 3 bulletins matters. Watch point 1. Further retrogression. If demand remains very high in EB1 for India or China, dates can stay back or move back more, especially as the fiscal year progresses and agencies manage the remaining numbers. Watch point 2. Forward movement later. Retrogression is sometimes temporary. If fewer cases are ready for final action than expected, or if demand patterns shift, dates can move forward again in later months. Watch point 3. Spillover and category behavior. Sometimes movement in one category affects others indirectly. For example, if fewer people can use EB1, more people might remain in EB2 or EB3, affecting future demand. Watch point 4. USCIS chart selection. Even if final action dates are tight, USCIS may still choose dates for filing in some months, which can be an opportunity for people inside the US to file and get EAD and advance parole while waiting for final action. And here is the big practical watch point. If you are close to the cutoff, a small forward move could open a filing window. Those windows can be short, so being ready matters. Before we close, one more high retention point. If you are an employer or a manager watching this, retrogression affects workforce planning. Employees may need to extend non-immigrant status longer than expected, travel plans may change, and job portability planning becomes more important once I-485 has been pending long enough to allow certain changes under the rules. Even if you are not the applicant, you can support them by planning ahead rather than reacting at the last minute. Now let's recap in 5 quick bullets. 1. February 2026 brings EB1 retrogression, meaning EB1 cutoff dates moved backward in the bulletin. 2. The biggest impact is often country-specific, and your brief flags India and China as key groups to watch. 3. If you are in the US, whether you can file I-485 may depend on whether USCIS is using dates for filing or final action dates that month. 4. Filing is not the same as approval. Retrogression can slow final approvals even after filing. 5. The best response is preparation. Confirm your priority date and chargeability. Monitor the bulletin and USCIS chart selection monthly, and keep your documents ready so you can act quickly when dates move. Do not panic. Retrogression is frustrating, but it is a normal feature of a quota-based system, and people still succeed through it every year with good planning. If you want, comment with your category, EB1, EB2, EB3, or family, and whether you are filing inside the US or through a consulate, and I will cover the most common confusion points in a follow-up. And if you rely on these monthly updates, subscribe and turn on notifications so you do not miss the next bulletin change that could reopen your window.